to welcome everyone to this week's Preparation Age Workshop, Preparing for Financial and Legal Matters. A bit of housekeeping before we begin. Many of you have sent in questions ahead of time, and our speaker will be addressing many of those in his talk. But if you have more questions as we proceed, feel free to add them to the chat. Just in case you're not aware, the chat is that little bubble in your lower bar of your screen, and you can just press on that. And when it comes up, it'll say to everyone, and just write your question and press enter, and we will try to get to it. Just as we budget and plan financially and legally for most periods in our lives, it is most important that we budget for old age. Preparing ahead and putting our financial plans and legal plans in order is the focus of tonight's talk. And here to lead us through it is Myles Fischer. Myles is an attorney practicing with Harris Beach Attorneys at Law. He counsels clients across New York and Florida on sophisticated estate planning, administration, and tax matters, to name just a few of his specialties. Besides his active practice, his community involvement includes membership on the board of directors of the Estate Planning Council of Eastern New York, Jewish Family Services, Fort Hudson Health Systems, Tri-County United Way, and many, many others. Originally from Rockland County, he and his wife and his 2 children now live in Half Moon. It is my pleasure to introduce Myles Fischer.
Hi, everybody. I'm going to share my screen here. Thank you so much for the wonderful introduction, the opportunity to speak to you folks today. And let me just figure out how to share here. Okie doke. Can you see the cover page? All right. Now the slideshow is, arts and creativity in terms of artistic production is not my strong suit. So the slides are a bit bare. There's only a handful of them. But this will be more of a discussion. There are so many questions. Thank you, everyone, for submitting so many ahead of time. I anticipate there'll be a lot more as we march through this stuff. What is important to know at the outset is that I am not a financial advisor. I'm an attorney. A lot of the questions were geared more towards a financial professional who will help budgeting, advise you on investments and things like that. Whereas that's not what your legal counsel is going to do. Your legal counsel is not going to, sell you insurance. Well, hopefully they're not going to sell you insurance, advise you on where to invest your assets and things like that. But what your legal counsel should do is the stuff we're going to talk about today. And let's go to slide 1 here. So estate planning: who, what, when, and why. Just the 20,000-foot view. Who should be who should engage in estate planning? The answer is everyone. There's really no good reason not to. And at any stage of life, at any stage of wealth, at any stage of business, there are always really good reasons, and that's sort of the why. The other multifaceted, the question of who should do this. From an advisor perspective, the client is the one that's estate planning, but who else is involved? The professional team. Your team of professional advisors is not just your legal counsel. It's like we just spoke, like I just mentioned, your financial advisor, your tax accountant, your CPA. Perhaps a trust officer if you are have a currently existing trust, or if you're a beneficiary of one. But those are sort of the core members of your team. And so what is estate planning? Estate planning is this umbrella term that encompasses so much. And you can just tell by the questions that you folks have submitted that, what is estate planning to one person is something totally different to another person. Estate planning can be asset protection for Medicaid purposes. Estate planning can be making sure your business passes, and seamlessly to the next generation. Estate planning can be, preparing your advanced directives for if something were to happen to you, if you were to become incapacitated and needed someone to carry out your financial affairs or your or make healthcare decisions for you. So it's sort of estate planning is managing your money so that you have a steady stream of income. Estate planning, is sort of all of the above. And so, we'll parse that out a bit as we walk through this, the presentation. But it's really unlimited in the directions it can go. So we'll, it's very individualized, and each client is different. Each person is different. Each family is different. Each business is different. Everybody has different goals. And why do you plan? For reasons like, business continuity, charitable goals. In the intro, I serve on JFS board, but there's a million charities that you can make part of your estate plan and do so in a tax advantageous manner if you're philanthropically inclined. And again, it seemed like most of the questions were hitting on this asset protection concern that folks tend to have, and so we'll get into that more so. I'm going to look at the chat here. Okay, that over here. One thing I want to hit on that is something that I get asked every time I do one of these, sort of talks. Somebody always has the question: if I don't do something, is the government going to get my money? Where will it go if I don't have a will? Does the government just glom onto it and take it? And so that's a more than one way to answer that question. But from a strictly state law property perspective, from that perspective, what the default is if you don't have anything in place is that the default statute essentially tries to find your closest blood. There's no law or rule or anything that says if you don't have your planning done correctly that the government is going to take it. Now, that's not an endorsement to not engage in planning. But it's the government doesn't just seize your assets if you don't have a will or a trust agreement or your beneficiary designations aren't in line with the rest of your planning. None of that there's no merit to any of that. So that's something that I get asked frequently. All right. So a lot of the questions that came in relate to the estate planning is lifetime planning and planning for what happens when you die. A lot of what the questions were focused on were powers of attorney, healthcare proxies, living wills. I'm not sure if maybe it was a question about MOLSTs, but these are all sort of documents that you should know what they are, know what they do, and save the most for your physician, but your legal counsel, you should have prepared at least a power of attorney and a healthcare proxy. A living will is more optional, but 99% of folks that I work with end up using them. Now, a power of attorney is a document where the principal gives the authority to an agent to act in the principal's best interest for financial transactions. Okay, and financial transactions can mean many different things. And what the power of attorney document specifies is it can be to engage in insurance transactions, to engage in real estate transactions, to engage in stock trading, to engage in to bring a litigation claim against someone, to do sort of there's a list within the power of attorney document that the client or the principal can decide what they want to empower their agent to do. The typical advice, and if your attorney is telling you something different, you may want to ask why, is to you want to give your agent broad authority. You don't know what you're going to need in the future. And so the point of the power of attorney is to empower someone to carry out these things if you can't. Now, the power of attorney by design is durable, and durable meaning in this context that it will survive your incapacity. And that's really the point. While you can take care of your affairs yourself, you don't necessarily need an attorney in fact or an agent. Those terms are synonymous. You don't necessarily need that that person to do stuff for you. It would be more of a convenience. You're in in Dubai and you have a real estate closing in Cape Cod, and you send your agent to execute the closing documents because you're unavailable. But really what most people would use that would find useful in the power of attorney is that when you start to fail a little bit, or you can't undertake your financial affairs all on your own, your agent steps in and they can pay bills, they can sign checks that from your checkbook, they indicate when signing those checks that they're signing as POA or attorney in fact. They don't just sign your name, but they're empowered to to pay the bills, do whatever they have to do in order to keep your financial house in order. It's a really, really important document, and it is one of the foundational tools that we use for clients. Now, when I started practicing this document, the power of attorney document was I think it was 3 pages. Now it is a 13 to 15 page document, depending on the modifications that the attorney puts in there. This document has gotten so incredibly complex, and a lot of it is over lawyering or these unfortunate situations of elder abuse, or taking advantage of some, I guess, elder abuse in a financial context, using the power of attorney in a nefarious manner. Now, the power of attorney, the attorney in fact has a fiduciary obligation to the principal. So when you are, and the attorney in fact also executes the form. So the principal signs the form, they initial in several different spots depending on what they've discussed with their attorney. And then the agent, whether in that meeting or subsequent, also executes the document. When the agent executes the document, there's a whole page that lays out all the responsibilities of the agent, no commingling of assets with their own, always having to act in the best interest of the principal, et cetera, et cetera. Now, when it's husband and wife, obviously, that stuff is less important. But if it's a single person, or if we're talking about the backup agent after husband and wife, all that stuff, the agent can be called to task for mismanagement or for acting outside of what's permissible in their what's prudent for a fiduciary. So and I think this is important for all the folks that were asking about Medicaid asset protection type stuff. What the power of attorney document can do is it can allow your attorney, in fact, to engage in Medicaid planning on your behalf. And so what we see occasionally is that the principal begins to fail, and it looks like they can't stay in at home any longer, and private aids are either too expensive or just unavailable for the amount of care the person needs, and they need to go into a skilled nursing facility. And so then the attorney in fact sits down with their legal counsel and says, what do I do? How do I qualify for Medicaid for mom? Or and hopefully at that point in time, when the power of attorney comes to the table, it provides that the agent can make transfers into trusts or to other individuals, other family members, in order to qualify for government benefits like Medicaid, which is a means-tested program. And so you can't, and we'll get into Medicaid in more detail, but the point being is that the document, the power of attorney document, is very powerful from an asset protection standpoint, a taxation standpoint. You can do deathbed tax planning using a power of attorney if it's drafted properly, and you can also transfer assets for Medicaid asset protection purposes. The other side of that coin is that you're entrusting someone fully here. You need to be comfortable with that. You need to pick an agent, even though they have the fiduciary obligation. If you have only if you have two children and you pick one, then the other one may be able to maybe a check and balance. That other child will be watching the agent. But in a situation where there's no family and you appoint a good friend or something like that, and they do something, there are cases, case law that has turned this document into an extremely complicated legal document because of situations where people have taken advantage of others. The point is, I'm not trying to scare you. I'm trying to say you should be educated about it. Your agent should be educated about it. You should be appointing people you trust. And I guess we'll leave it at that for now. Healthcare proxies and living wills. These are advanced directives related solely to healthcare decisions. Now, a healthcare proxy is a form on which the principal is appointing an agent to act to make healthcare decisions if the principal is unable to make their own. So unlike the power of attorney, which comes into power immediately upon signing the document, the healthcare proxy is a springing authority. So put another way, as long as the principal can nod their head, draw a picture, type their wishes, the attending physician is to take their direction. If they cannot communicate their health, sorry about that. These lights are on a timer. I'm not moving enough. It thinks I'm dead. So the healthcare agent can make decisions if the principal is unable to communicate their own wishes to the provider. And what the healthcare proxy document says is that my agent will make decisions based on the discussions that I've had and the instructions that I've provided to them. And the alternative here, I don't know if anybody remembers at this point, it was sort of a couple decades ago now, but the Terry Schiavo case and saga that sort of surrounded and brought these issues to bear or to the front page news, where you had a husband and parents of an incapacitated person, Terry, and they differed on how they wanted their thoughts on end-of-life care for her. And so the healthcare proxy alleviates that. If a principal has appointed an agent, that agent will be able to make the decision as to medical decisions. Now, what the document says is they're going to make a decision in accordance with the instructions that I've given them, but ultimately the healthcare agent's decision or interpretation of those instructions will govern. Now, what it depends on the attorney you're working with. But what we say in our healthcare practice, and I'm sure it's fairly common, is that if I don't have that conversation, if I never get to have that conversation with my agent, or just as guidance to my agent, I want them to make healthcare decisions for me in accordance with the New York Living Will. And what the New York Living Will says, another form, just a one-pager, not that complicated, but quite consequential, is that it says if the principal is in a terminal, incurable, and irreversible condition, that they do not wish to have, with the likelihood of recovery, virtually a medical certainty of not being able to recover, then what they're instructing their agent to do is not prolong their suffering, no artificial intubation, no artificial hydration, no feeding, no machines keeping you alive if you're in a vegetative type state, and that you want maximum pain relief, but that the artificial means keeping you alive should not be administered. And so, people's views differ on that. And I've had folks tell me, I want to be kept around for 180 days just to make sure, and things like that. And some people say, I can't sign that. I had an uncle that woke up after 10 years. And there's no requirement, to do that. But I find, over the last 13 years of practice, 98% of the folks end up signing the living will and, wish to have the plug pulled if they're in fact in one of those conditions. The other documents that you may have heard of, a MOLST, a medical order of life withholding treatment or something like that, and a DNR, do not resuscitate. Those are documents that are physician prepared and physician signed off on. Those are not lawyer documents. If your lawyer's preparing you a DNR, you got to go somewhere else, because that's not what we're authorized to do. And what those documents are, those are more, DNR is more you're in the hospital or in a setting where you have an end stage condition or something like that, and you don't want to be resuscitated if you were to you're have a heart attack and you've already you've done chemo and all sorts of stuff and you're sort of at the end. So that's one of those something you should speak with your medical provider about it if it in fact is applicable for you. Let's see here. A lot of times, this is a good, I'm not sure if somebody asked this or if it's just a frequent question. Folks say, can I print these documents online? And this is not a business opinion. I've got more than enough work to do. I would very much discourage you from doing that. Every document, power of attorney, healthcare proxy, and living will that I prepare is altered from. There's a statutory form for the healthcare proxy, and there's a Department of Health form for the living will. But the modifications are what makes the document, what I think makes them most helpful. And so I would, you may print them to view them, and I just would encourage you to be careful when doing something like that, because for example, the power of attorney, all of the modifications that allow gifting for Medicaid or tax purposes, those are not in the form document. Those are all built in by the lawyer, the draftsman. And so if you think you found it online and you're going to sign it and get it notarized, witnessed and notarized, and you think you're good to go, I would just have that maybe checked by the lawyer or something, just to make sure that it is in fact going to accomplish what you want it to, because that's a sad situation, if it doesn't. So talking more than I've 37:27. So estate planning, disposition of assets. Before we get into wills, trust agreements, beneficiary designations, and asset titling. I think that it's a good juncture to explain to folks what probate is, because I'm going to use that word a lot when I'm talking about these bullet points here. So probate is the process of admitting a will to the court, and the court filing the will with the court with a petition, and the court admitting the will as valid and appointing the nominated executor under the will as the fiduciary and granting them the authority to carry out the terms of your will, what you've laid out in your will. Your executor in New York, your personal representative in Florida, their job is essentially to do what your will says. They have to execute on the instructions that you've given them. And it can be give all my money to JFS. It can be, set up trusts for my grandkids and give them, $15,000 a year until they're 50 and then distribute the whole thing. Whatever your will says, your will says. But probate, the probate process is something that gets talked about, and also there's a lot of misconceptions about it. So you die, you have assets that are in your name alone that pass into your probate estate. Okay, so meaning that they're not jointly held with another individual. The assets, they're not payable by contract like a life insurance policy or a beneficiary designation like on a retirement account. They are they're in the decedent's estate, and in order to direct them, there needs to be someone appointed to do so, and there needs to be the instruction manual, the will, for that person to know what to do with the assets. And so what folks, when preparing for a probate of an estate, the nominated executor comes in and says, okay, mom passed away, and here's you did the will. She had the house. It used to be in mom and dad's name together, but dad died 5 years ago, so it's only in mom's name. How do we get the house to me and my sibling, who are the remainder beneficiaries under the will? And how you do that is through the probate process. And what that means is you file the will, you file the petition with the court, you notify everyone that would be a natural heir at law if that will didn't exist. And we'll get to that in a second. That is, that's required in order for the judge to say, okay, here's the will, here's who would have inherited the property if this will was invalid. All of you folks come state your case why this will shouldn't be admitted. And then after that's all said and done, the judge says, okay, the will is valid or the will is not valid, and here this person should be the fiduciary, and here you go. So what you have is there are really good reasons why you may want to avoid probate, but simply just avoiding probate for no reason is sort of an oversold lawyer thing that I would discourage, because probate in our local area, the upstate counties in New York, is not a particularly burdensome process. Okay, probating down in Nassau County or the boroughs, the 5 boroughs, it may take a lot longer. In Albany County, you can get a probate done in less than 2 months. So that's just something that you should be aware of. And one thing that we should hit on a little bit, though, is who would be your natural heirs at law that would be required to get notice in a probate proceeding. Okay, so what that means is that, let's say I'm married, I leave everything, instead of leaving everything to my wife, I leave everything to my girlfriend. Okay, I leave everything to my girlfriend when I die. The will, my girlfriend comes into the law office, she gets a copy of the will, she files it with the surrogate's court. The surrogate's court is going to say, okay, you have to serve notice on his wife, because under the statute, the default law says his wife and his kids would inherit if this will was thrown out. So then my wife could come and my kids could come and say, well, dad was, wasn't of sound mind when he was writing this and blah, blah, blah. And so that's the give and take in the probate context. You open yourself up a little bit to objection, and also wills are absent some particularly detailed financial information that's redacted. It's public record. The surrogate's court files are public. So what folks tend to do if they think there's going to be a will contest, or if they think that there's going to be somebody coming out of the woodwork that would need to be notified or cited in the proceeding, what you tend to see is people use other vehicles that avoid probate, like a revocable trust agreement. And all trusts are non-probate vehicles, and the assets within those trusts all pass outside of probate. Okay, so they're not monitored by the surrogate's court. They're still subject to the surrogate's court's jurisdiction. And so a common misconception is, oh, I'll use this revocable trust and nobody can challenge it. That is not the case. That's not what the law says. It can still be challenged, and they quite often are. It may be a one step a little bit more difficult, but it still is within the purview of the surrogate. So, man, run out of time. So, okay. So disposition of assets, wills. Your will appoints your fiduciaries, your executors. It could appoint trustees of trusts that you create under your will. Testamentary trusts. A trust created under a will is a testamentary trust. A trust created in a lifetime trust agreement is a lifetime trust, or an inter vivos trust. Now, what many people have trouble reconciling is that you can create, and most of my young clients that have young kids, they all have trusts under their wills because that they have kids that are 5 years old that if God forbid something happened to them, they don't want the money to go outright to the kids. So you have trust for minors, trusts that hold the money until the kids are 25, or half at 25, half at 30, something like that. So that's totally plausible and something that is done very frequently, having trusts underneath your wills. There's also certain tax planning mechanism. A lot of you may have heard of AB trusts or credit shelter trusts, family trusts. These are all tax planning type trusts that can be established under your will. We'll get to tax planning in a second. But also what folks can do in a will, you can nominate guardians for minor children. You appoint executors, you appoint trustees, you appoint backups to executors and trustees. You can do some tax planning. You can also, you can create a charitable foundation under your will. You can make, bequests to anybody. You can dispose of your tangible assets. So, my engagement ring to my eldest daughter. You can create a trust for your pets. We've done a couple of those lately, but there are some caveats there. You can't leave the pet $1 billion. That wouldn't fly. But so then you have your wills on the one hand, and then you have trust agreements on the other. These are non-probate vehicles where you can title assets inside a trust, and then when you die, the trust says what happens. And so there's no need to go to the surrogate. And why would you want to do that? Again, the will contest scenario, or if you have long-term trusts that you're going to create, trust for life, or a special needs, supplemental needs trust, something that will carry on for decades. You typically don't want to do that under a will, because there will come a point in time, when you have to go back to you're always under the purview of the surrogate's court. And so doing it under a lifetime trust agreement, you're outside of that, needing to go back to the court periodically. Now, trust agreements, somebody's typing in the chat, about there's a Medicaid asset protection trust. Trusts come in a million different flavors. They can be revocable, they can be irrevocable, they can have tax planning in them, they can be dynastic, they can continue perpetually depending on the jurisdiction you're in. This area of the law has like a million different acronyms. There's Q-tips, Q-perds, slats, idiots, eyelets, grats, crats, cruts, all sorts of these, funny names that if you spell wrong, you get in trouble. But they're useful for various different things. And so what we do in the Medicaid context is, I probably should start talking about that since that was the most asked question, I think. Medicaid trusts are used because what Medicaid says is, in order to get Medicaid benefits, you can't have, it's means tested. So you can't have $1 million and tell the government, well, I need to go into the skilled nursing home and I need the government to foot the bill. That's not going to fly. So what you do is, if you have time, and time is necessary because there's this look back period component to things, is that you can part ways with your assets by placing them in a Medicaid asset protection trust, an irrevocable trust that you only retain certain rights to those assets. And for Medicaid purposes, it no longer counts, okay, when they're looking at all of your application, which is essentially a very invasive, all of your financial history, gifting, et cetera, et cetera. Now, when you create the asset protection trust, you can't do it if you can, but for it to be most effective, you can't do it on Monday and then say, okay, Medicaid, I put everything in the asset protection trust, I'm ready for the government to pick up my bill. That's not how it works. So there's a 5-year, 60-month look back period where they'll look back for uncompensated transfers, gifts, okay? And so you kind of want to do the Medicaid asset protection trust at least 5 years out of when you're going to need to apply. If you knew when you were going to need to apply, you would have a crystal ball, and then you would hit the lottery. You would be able to pick the lotto numbers. So the earlier the better is one way to think of it. Now, Medicaid. Well, I guess I'll wait for questions on more Medicaid stuff. Beneficiary designation. Everything should be working in concert. Your will, your trust agreements, your beneficiary designations, your asset titling. If your attorney can draft you the most comprehensive, beautiful Jeffersonian language in your will and your trust agreement, and if everything you have is titled jointly with your spouse or titled jointly with your daughter or whomever, when you die, your will doesn't enter the fray. Everything goes to that surviving joint owner. Everything gets paid. The life insurance policy goes to the beneficiary. It doesn't enter your estate unless there was no beneficiary designated or no joint owner or no other passage of title outside of your estate. So you want to make sure all these things are working together. If you're pursuing a probate avoidance plan for whatever reason, but you forget to designate the beneficiary of your life insurance policy, it'll get paid to your estate. And then you've botched that. Your attorney has botched that by not making sure everything fits together. And that's part of this. Let's see. Intestacy. So intestacy is what happens if you die with no documents. Where does your stuff go? And it's essentially closest blood. It's where does New York State law think you would want your property to go? And this is very interesting. At least I find it. I'm a weirdo, but what happens is if you die without any property, without any will, without anything governing your you're, no joint owners, no beneficiary designation, and no will, the default law says that essentially your spouse gets half and your kids, now not minor kids, adult kids too, the statute uses the term issue, descendants, your descendants get the other half. So think about that. You have a house that you lived in with your wife, her name wasn't on the deed, you go out and get struck by lightning and die without a will, that house is part of your probate estate, your wife gets half of it, your kids get half of it. Who thought that was a great idea? I don't know, but that's what the law says. So incentive to plan properly and think about these things. It was interesting. There was just an article within the last 2 weeks about a guy he died in 2016 in Chicago, Joseph Stanchak, he died without, he was, I think, 87 years old. He had never married, no kids, and had 6 siblings who all predeceased him, none of whom left children. He died with $11 million. Nobody knew that this, it was like kept to himself and just, I don't know, was wildly successful in diversifying his brokerage accounts. And his estate, they just figured out who will inherit his estate. And there's 119 heirs at law based on the Illinois statute, because there's nobody, he had no descendants. His parents were dead. He had no siblings. His siblings had no descendants. So you look up to descendants of grandparents. There were people all over Eastern Europe. There were, 190. The list of people takes up an entire conference room table. That's the kind of stuff you want to avoid. I mean, especially if you have 11 million bucks. Not good planning. Taxes are only relevant to a small percentage of the population at this point, because the exemption levels are so high. And when I say that, I'm talking about estate tax. Federal estate tax applies to individuals that have assets in excess of $12,060,000 this year. And that's portable between spouses. So each spouse has 12 million, and if one dies, they can leave the exemption to the surviving spouse, and it's 24. They have then the surviving spouse is 24 million. Now, that's going to drop down. That part of that came with the Tax Cuts and Job Act of effective 2018. And in 2026, the 12 million will drop down to about 6.5, 7, 5 million adjusted for inflation. And with inflation, it could be 6, it could be 7. We're not quite sure yet. And New York State has an estate tax as well. And as lucky residents of the Empire State, you will pay New York State estate tax if your estate exceeds $6,110,000. That's not portable between spouses. It's use it or lose it. So it's not like the federal estate tax. The federal estate tax is a flat 40% rate. The New York State tax is bracketed marginal rates like your income tax brackets between 2.5% all the way up to 16% for estates over $10,100,000. Income taxes, they're always relevant. Obviously, when you die, we could do a little bit of a tax 101. You buy AT&T stock 20 years ago when it was worth $1, and you died when AT&T stock was worth $100. If it's includable in your estate, then your beneficiaries get that stock with a basis of $100. So if they were to go to sell it the day after you died, they would not pay any income tax. So there's this adjustment to cost basis when you die. You get a lot of people refer to it as a stepped up basis. So that's something to be conscious of when talking to your advisors. What you don't want to make a gift of, because a gift carries its basis to the donee when you make a gift. So there's planning opportunities there, I guess, is what I'll leave it at. All right, let's get to some questions. I guess. Well, so let me pull up here. Hold on, I'm gonna do this. Okay. Now, there were like 3 pages of questions, so I want to.
Maybe we should Miles, excuse me, I'm thinking maybe we should just look at the chat first, just because these
Okay.
people are live right here.
No, fair, fair.
So I can start with one of them. Are there things that supersede others related to death? For instance, does a life insurance policy with a designated beneficiary supersede a will?
Yes, yes. So great question. You want to have your stuff fit together like a puzzle. And so what you don't want to do is say in your will, I leave my life insurance policy to my daughter and the beneficiary designation says to my son. But what the law says is the beneficiary designation carries the day. So if the beneficiary designation is valid, it wasn't, done improperly or by someone that wasn't authorized to do so, the beneficiary designation is what will govern.
Okay.
That goes to the point about having the most well drafted will that has beautiful crystal clear ornate language, but if everything's titled as a joint asset, it just passes to the surviving joint owner by the beneficiary designation. So the will never comes into play with respect to those assets.
Okay. Back to the Medicaid Asset Protection Trust. There was another question. You answered what it is and explained that. After setting up the MAPT, what strategies can be used for accessing one's assets if they are needed?
So, I am not a Medicaid focused attorney, but what I could tell you is that most of the Medicaid asset protection trusts have discretionary authority in the trustee to make distributions to the grantor's children. And so this is the typical method is there's this backdoor approach. So the grantor who's created the trust that wants to apply for Medicaid can't have access to the trust principal asset. There can't even be discretion to make distributions of the principal assets to the grantor. Only income. Okay. I'm not sure if that's a clear concept, but there's principal and there's interest and dividends that come off of principal income. Now, how you get around how Medicaid folks use this backdoor principle of if the grantor needed access to principal, the trustee can make a distribution to the children, assuming the trust allows for that, and then the children could then spend the money on mom or give the money to mom. Now, inefficient for tax purposes and for all sorts of other reasons, but that is a strategy that can be used if you need it in a pinch.
Okay. Here's one. Is there a reason for putting one's home in a revocable trust?
So yeah, there could be. A revocable trust does nothing for tax purposes. It does nothing for creditor protection purposes. When do I use revocable trusts? If I have someone that resides in a jurisdiction or in a surrogate's court venue that might take a year for them to get appointed. All of my clients in the 5 boroughs, we use revocable trust. 98% of my clients in Florida, we fund revocable trusts with their homestead. The reason is because probate is going to take longer in those jurisdictions, and it's beneficial to put them in a revocable trust. Now, there's also the concept of you have 2 residences. You have a homestead in Albany and you have a house on the Cape. What would happen in that instance is you would have to probate in New York in order to move your New York residence where it needs to go. And then you would need to do what's called an ancillary probate in Massachusetts in order to get authorized, to get your executor authorized to move Massachusetts real property, because the New York proceeding is not going to govern the Cape house. So where you have multiple residences, we typically put the non-domiciliary state residence, so the Cape house, the vacation home in this context, would be put inside the revocable trust, so that this way, when the person dies, if you have to probate, you're only probating in New York. You don't have to bring an ancillary proceeding in a second jurisdiction.
Got a couple more. Are there things that supersede others related to death? For instance, does a life insurance policy with a designated beneficiary supersede a will?
So yes, I think that was, I'm not sure that's different from the question that the other person asked, but yeah, if there's a validly executed beneficiary designation that's filed with the life insurance company, that doesn't touch the insured's estate. That will, the life insurance company is going to send a claim packet to the person who's listed on that beneficiary designation form. Now, if that person is dead and the beneficiary designation form doesn't provide for a contingent beneficiary, then the policy will get paid to the estate, depending on what the policy contract says. It may say, we'll pay it to your closest blood, but oftentimes it pays to the estate. So that could happen.
Okay. When would you use an irrevocable trust?
You would use an irrevocable trust, several reasons. Tax planning. Whenever you're tax planning and you need to part ways with dominion and control of an asset, you can't put it in a revocable trust that you can take back at any time, because the tax authorities will say, well, then you didn't part ways with it. It's still includable in your estate for estate tax purposes. And so you would use an irrevocable trust in that context. All the Medicaid trusts, Medicaid asset protection trusts, they're all irrevocable. A revocable trust does nothing for you in a creditor protection or a Medicaid asset protection scenario, because it's revocable. The trustee or the grantor or both can collapse the trust, in their discretion. Revocable trusts are probate avoidance vehicles that's the only use for a revocable trust. And so we talked about why you may want to avoid probate. It's a little bit tougher for a will contest. You don't want to probate in multiple jurisdictions. You have long-term trust created that you want to create, so you want to stay outside of the purview of the surrogate. So all those reasons would make revocable trust, advisable, but not. But irrevocable trusts are asset protection and tax planning.
Right. We're going to wrap up in a couple minutes, but I just have a couple questions that were sent in earlier. Someone was asking about the duration of a power of attorney. Is there a termination date?
Yeah. Yes. So the power of attorney is revocable, or as long as the principal maintains capacity to revoke the document. You can appoint, Joe Schmo to be your attorney in fact, and you have a falling out with that person, you could terminate the authority under the power of attorney. But I think what the question is more geared towards is your power of attorney is only effective as long as the principal is alive. Okay. And it's durable, so it survives incapacity. I've never seen a power of attorney that said this power of attorney is good for 5 years, or something like that. Maybe a specific power of attorney for someone just to do a real estate transaction or something like that. But the powers of attorney that we talked about today, a durable power of attorney designed to sort of facilitate someone's financial affairs when they become incapacitated, survives the whole duration from execution until they die. As soon as someone dies, as soon as the principal dies, so does the authority for the agent under the power of attorney. Power of attorney only while the principal is alive. Once the principal dies, then we're talking will, executor, and that phase of documents. And
how about in respect to the probate of the will, the length it takes for process and the usual cost of that?
That's kind of a tough question, because it sort of depends on a lot of things. Now, probate is just a process where the court, you get the will admitted and the executor appointed. Then there's the whole administration of the estate. So once the executor is appointed, then they have to marshal the assets. Then they have to open up an estate account. Then they may have to file an estate tax return. They have to file fiduciary income tax returns. They'll have to pay bills. They'll have to, do all sorts of stuff. They'll have to wind down a business. They'll have to sell a house and distribute the proceeds, all that sort of stuff. That takes time. So the probate, just getting the will admitted to court, the quickest you can do is probably a month or two. And that's because we have wonderful local surrogates courts. I've had folks die while waiting for their petition for to be appointed in New York County and in Nassau County. It could take a year, especially when COVID was going full tilt. They were just, that could take a real long time. As far as cost goes, we work on an hourly basis. There's no flat fees sort of stuff because it's not fair to the client and it's not fair to us. So we don't know what we're getting into. But a probate petition, again, Mr. Stanchak in Chicago, to get notice of his estate, you could, if you're one of those, it's going to cost you a pretty penny. Let me tell you, if you're not, a couple grand, it would probably take just for a probate petition.
Okay. I have a final one. I'm not sure if you're going to be able to help me with this. Is there such a thing as a list of people, businesses, government agencies, sort of like the mother list, to contact upon the death of a spouse? Is that something you guys have that you give to your clients that we could share with the people who are on tonight?
So we don't have some exhaustive type list, but it's really not that, you shared, Linda, your list, which is really comprehensive and excellent. Part of the estate planning process is getting organized, keeping a list, keeping your estate planning binder with your documents in a place where someone could find it and that has the attorney's card in it, so that when something does happen, they know where to call. Because whenever I'm doing estate planning for someone, I have this whole intake questionnaire that serves as the basis for my file. So it has all of the family, it has all of the assets laid out. But there's typically the funeral home notifies Social Security, and so they, and once it's in the Social Security database, then the insurance companies find out. But as long as if you're organized, monitoring the mail is obviously, every attorney that does what I do has sat down with the surviving spouse that was totally uninvolved in the finances. And it's heartbreaking because they're just lost. But, provided they were clients when they did the planning, we have this dossier with all the information, and that's important. And you should be, I think, forthcoming with your counsel in terms of providing them all that stuff, so they have the file, the background, and know who to contact. But monitoring the mail, looking at previously filed income tax returns, so you can see where the 1099s were coming from. You could see, the mail will tell you when insurance, who they paid insurance premiums to. Social Security will suck the money right back out of the account. If you don't survive the month, they'll take it back. So, they'll get notified. You don't have to worry about Social Security. But yeah, there's the only thing I would say is I don't like safe deposit boxes. You shouldn't keep your stuff in a safe deposit box because you end up needing to get access, and that's a separate court proceeding. If nobody can find, there's nobody authorized to get access to that box, and your will is in there, or your list of all these every important document. It creates additional hurdles that should be avoided.
Thank you so much. This has been incredibly enlightening. You did a great job and we appreciate it so much. I hope that everyone's questions were answered. I'm going to turn it over to Monica for a final wrap up.
Hi, everyone. So thanks for coming. I don't want to give Linda a heart attack, but after tonight's talk, I could see doing at least 6 more workshops alone based on what we covered tonight. We're sending out evaluations in the morning, so please check your emails. These evaluations are really helpful for giving speakers feedback and shaping what we can offer in the future. I want to remind you that JFS services are available for anyone who needs them. We have clinicians who do counseling and support groups. We have experts on aging that can help you navigate any questions about aging and resources. We have case managers who can help with paperwork navigation, private transportation for seniors, kosher home delivered meals. And then I want to always put in a plug that we're always looking for volunteers to do one-time, periodic, or ongoing volunteer activities. So we hope you'll join us next Tuesday. We're covering health and wellness. We have Dr. Michael Wolf, who is an internist and a geriatrician, and a GFS board member, Jane Sanders. She'll be covering Medicare and insurance considerations. So thanks for joining. Thanks for your great questions. And that's all I have.
Thank you, everybody.
Okay.
We'll see you
thanks.
next week.
Okay, bye.